NACDL's Director of Public Defense Reform and Training, and it's my pleasure to welcome you to today's webinar, Defending Women Charged with Crimes in Relationship to Pregnancy. Today's program is brought to you by a grant from the Bureau of Justice Assistance. Our presenters today are from National Advocates for Pregnant Women, an organization working to ensure advocacy excellence on behalf of women who are being prosecuted and punished in relationship to their pregnancy. A couple of logistic matters before we get started. If you have any questions during the program, please submit them via email to Diane Price at dprice@nacdl.org, and that email address will be shown on the video throughout the program. As well, today's program is eligible for CLE credits. You'll see our verification code at the bottom of the webinar. Please take note of the code and follow the directions in today's emails to submit that code at the conclusion of the program. I'd like to introduce to you today's presenters. Lynn Paltrow is the founder and executive director of NAPW. Founded in 2001, NAPW is a nonprofit working to secure human and civil rights, health and welfare for all, with a focus on pregnant and parenting women, especially those most vulnerable to state control and punishment. Ms. Paltrow previously served as a senior staff attorney at ACLU's Reproductive Freedom Project, the director of special litigation at the Center for Reproductive Law, and vice president for public affairs for Planned Parenthood of New York City. She's joined by Dan Arshack. Dan is a former public defender, co-founder of the Bronx Defenders, and managing attorney at the law firm of Arshack, Haycheck, and Lehrman. And Nancy Rosenbloom, the director of legal advocacy at NAPW. Nancy spent the last 25 years fighting for equal justice. Through a combination of individual client representation, impact litigation, policy advocacy, and training, she's handled civil rights, family law, reproductive rights, education law, and criminal defense matters. She was a senior staff attorney and director of special litigation at the Legal Aid Society of New York City, the director of judicial strategy at the Center for Reproductive Rights, and project director for the City Bar Justice Center. With that, I turn things over to Lynn, Dan, and Nancy.
Hi. I'm Lynn, and I like to add to my bio that I'm a Gemini and mother of twins. And as the founder of National Advocates for Pregnant Women, NAPW, sometimes the simplest, if not most indelicate way of explaining who we are and what we do is that NAPW is the organization you call if you have a client who is locked up because she's knocked up. We're based in New York City, but we work on cases through pro bono assistance with advocates across the country. And our commitment is that we do not litigate and leave. We seek to assist and support appointed and retained counsel, and our assistance can take many forms depending on what's most appropriate in any given case and considering any locality. So it might be simply providing some advice. It might be a co-counseling arrangement. It might be helping you identify and providing experts who may be available on a pro bono basis. And we often represent leading medical organizations and experts as amicus, as you'll hear, even at the trial court level. So what do? Our litigation and legal advocacy focuses on cases in which being pregnant is an element of the crime charged. In other words, but for pregnancy, the person's conduct, circumstances, health outcomes would not have been investigated or punished. And we just want to acknowledge that you might, at some point, have a client who's a pregnant woman. It might also be a pregnant man, a transgender man who is pregnant, who might need your representation. What do we mean by pregnancy as an element of the crime or a but-for situation? Here's some photos of cases we've been involved with. And what it really means is that because the person is pregnant, something they did or didn't do that is otherwise not criminal somehow becomes criminal. And I'll give you some examples. In Christine Taylor's case, she fell down a flight of stairs while she was in her second trimester of pregnancy. She went to the hospital to make sure her baby was okay. In the course of talking to healthcare providers, she admitted that she had earlier thought about potentially having an abortion. She was fine. She was going to go home to her two little girls who were at home. And on the way home from the hospital, her cab was stopped by a police car, and she was taken into custody and arrested on the charge of attempted feticide. So The action that they said was criminal, falling down a flight of stairs, is not normally criminal, but because she was pregnant when that happened, it became an excuse to arrest her. Immediate national outcry resulted in her release and the charges being dropped, although the possibility of that happening again is unfortunately quite real. Other examples of but for the pregnancy, the action or the alleged action would not have been a crime, would include cases in which a woman drinks alcohol. Drinking alcohol is not a crime. Uses criminalized drugs. In most states, it's possession, not use, not having an addiction or use that is actually criminal, except, according to some prosecutors, if the person is pregnant. Some of the pictures you're seeing, I think on your far right, is a woman who was about to be released from incarceration. She had been held on an immigration charge. All the parties agreed that she should be released, but when the judge found out that she was pregnant and HIV positive, neither of which are crimes, the judge believed he had the authority to keep her locked up on the very wrong belief that the fetus, the child within her, would be healthier if she were kept incarcerated. We intervened and helped get that decision reversed very quickly. Other circumstances or actions that are not illegal, that might be treated as if they're a basis for arrest or detention, might be refusing prenatal care, as the woman in the lower left-hand corner was taken into custody. She was in a religious community that didn't believe in medical care, and her refusal of prenatal care became the basis for her arrest and forced medical examinations. Refusing cesarean surgery, the woman in the white shirt in the very middle picture, and attempting suicide. The graphic, Free Bebe Shui, in no state in the United States is it a crime to attempt suicide, to be human, to experience depression, or whatever it is that leads people to give up hope and attempt suicide. The fact that she attempted suicide while pregnant, she ultimately underwent cesarean, she ultimately was found before she died. She attempted suicide by using rat poison. She was found, she went to the hospital, she wanted very much to have this baby. She did everything they asked her, including undergoing cesarean surgery. The baby was born alive and then died, and she was charged with attempted feticide and murder of a viable fetus. And we'll be talking about those and other cases. The other kind of case is pregnancy is obviously, or maybe not so obviously, is a necessary element of the crime in any case, in every case in which a woman has had a stillbirth, a miscarriage, given birth to a baby who has some alleged harm or was exposed to some alleged risk of harm, and any case in which a woman is being charged because she sought to or did terminate her pregnancy. So again, none of those things could be criminal without first having the capacity for pregnancy and becoming pregnant. Today's program focuses on abortion cases, but all the cases are related and raise similar questions, build on each other, and make use of the same kinds of defense and offense strategy. I'm going to turn my talking over to Dan.
That's great. Thanks, Lynn. And I really want to thank each of you for taking the time out of what I know is a busy day to pay attention to the issues that we're going to be talking to you about today. I have a background, as you heard, in public defense. I was a public defender for years, started a public defender's office in the Bronx, and still practice almost exclusively criminal defense work. And I've been working with NAPW for a couple of years and have been both heartened and fascinated by the kinds of cases that we get involved with. And I want to assure you, as you listen to today's presentation, that these are cases that you can win. They provide an opportunity for creative and aggressive litigation. There's nothing run-of-the-mill about these cases. They're all unique. And while these sorts of cases are not common, they're not like shoplifting cases or burglaries that are apt to come through a public defender's office or criminal defense attorney's office on a regular basis. When they do arise, we need to recognize that that these cases focus a buried and palpable hatred against women who are making decisions in relationship to their pregnancy. That's why these cases happen. Sometimes those decisions that are made out of ignorance and poverty and desperation. Sometimes they're decisions which come from considered thought and cogent, reasoned decision-making. And sometimes perfectly innocuous conduct, like falling down the stairs, is criminalized due to pregnancy. In every case, though, the criminalization of the ways in which women engage with their own bodies, especially during pregnancy, deserves a fresh look and a creative response. The information you'll hear today is designed to alert you to the avenues that you might explore in a variety of situations. We hope that when you have a case that raises the sorts of issues that we'll be talking about today, you'll consider NAPW as a resource available to you to be a partner with you in protecting your clients.
So there have been, in the last few years, 5 fairly high-profile cases in which the allegation against the woman involved the claim that she sought to terminate her pregnancy, or actually did. Before we get to those, and before we get to the fact pattern, we think that some history is going to be helpful. So, I'll give you some background about abortion law in the United States and why we think there are going to be more of these cases coming up. So we start with the fact that abortion was not a crime in the United States of America until the mid to late 1880s. It was not a crime either at common law. And while there were a number of reasons these laws were passed, one of the reasons was because at that time, abortion was very dangerous. Now, the truth is, so was childbirth, but it was very dangerous, and a purpose of these laws, at least an articulated purpose, was to protect the health of pregnant women. Despite the fact that by the 1970s, almost every state had a law criminalizing abortion, a few had started to reform and repeal their laws. What we know, and I'm sure you're well aware of, is that prohibition doesn't work. And whether you're prohibiting drinking alcohol, prohibiting the use of selected criminalized drugs, or prohibiting women from doing what they feel they need to do in relationship to their pregnancies, it does not work. So during the period leading up to 1973, it was estimated that between 200,000 and 1 million women every year had what would have been considered illegal abortions. So, as I'm sure you're aware, in 1973, the U.S. Supreme Court decided Roe v. Wade. And in so doing, it effectively struck down, overturned every state that had a criminal abortion law. The important things for today to remember about Roe and the subsequent cases is that Roe v. Wade did allow states to impose certain regulations, and among these it said states could require that only doctors perform abortions. The thing about that, however, is that the Supreme Court wasn't deciding between doctors and the woman herself. They were only looking at the question of doctors versus back alley abortion providers and other kinds of health care providers. In fact, the U.S. Supreme Court has never addressed the question of whether a woman herself could be punished for having or carrying out an abortion on herself. The decision also made very clear it did recognize at that time a state interest in potential life only after viability, something that occurs at a different point in every pregnancy. It's not clear that judges and others understand that. For example, you might have a 9-month pregnancy where the fetus is not viable because, for example, it has anencephaly, the brain hasn't formed. In any event, even though it recognized a limited state interest in potential life, one that has in subsequent cases been articulated as perhaps existing throughout pregnancy, it said, and continues to be the law, that the woman's life and health must be the state's paramount interest. And that's important to remember in all of these cases. We're going to talk a little bit about where we are today. Today's presentation is about how many, many things have changed since Roe v. Wade, since 1973, that make arrests and punishment of pregnant women, of women who've had abortions, far more likely and also more acceptable in some communities and political environments. I start from a very popular claim that prior to Roe, no woman was arrested for having an abortion. And some of those who support anti-abortion laws claim that they don't want to have women arrested, and they never were. And there are two problems with this claim. And the first is, in fact, some women were, in fact, prosecuted, arrested and prosecuted and convicted of various crimes in relationship to their efforts to get abortions when it was criminalized. One of these women was Shirley Wheeler in Florida. What would typically happen if a woman obtained an abortion and something went wrong, she would go to the hospital. There would be a bedside interrogation with the hope of getting the name of the person who performed the abortion and prosecuting them. Ms. Wheeler did two things. One is she didn't turn in the person who performed the procedure, and she survived. When she survived, she was charged with a manslaughter charge, not necessarily specifically an abortion charge, and was convicted with a potential sentence of 20 years of incarceration. To give you some idea of how these issues, and still very much today, are really about how we think of women and their proper role in society, the judge did not sentence her to 20 years of incarceration. Instead, the judge gave her probation, and the probation required that either she marry the man who she was currently living with, or that she move out of state, return to her home state, and live with her parents. This was an adult woman, and this was the penalty. It's false. The statement that no women were arrested is false, because women were, and they were arrested as accessories and subject to interrogation. But that statement is true in a way. And the way it's true is because prior to 1973, most people didn't get arrested for anything or didn't go to become incarcerated for any crime. And this is some data about arrests and incarceration in our country that leads the world in incarceration. In the 1970s, there were approximately 300,000 prisoners, men and women. And today, with the advent of the war on drugs and mass incarceration, we have 2.2 million people in prisons and jails in the United States. So again, the idea that women weren't arrested for having abortions before Roe really has more to do with the fact that women and men, weren't arrested for crimes in general. That was not how our society was dealing with the many health and social problems that people experience. This is a graph showing specifically the growth in incarceration of women. And again, this is in large measure due to the war on drugs. If you haven't read The New Jim Crow, I highly recommend it. We should be also showing you the cover of Dorothy Roberts' book, Killing the Black Body, that talks particularly about the targeting of African American women for surveillance and punishment. So we now have a situation where we have the fastest growing proportion of prison population is women. And most of those women are mothers. The idea, if there had been any protection, because the people who were being incarcerated, the women who were incarcerated, were taking care of small children, any hesitancy to incarcerate because of that, it no longer exists. And here's another graph showing the extraordinary growth of incarceration of women up to 2014, with 1.2 million women now under the supervision of the criminal justice system. And really, if your goal, because one of the questions I think it's important to ask in general is like, who profits from any of the policies that we're all dealing with? You know, if your goal was to keep private prisons and the folks who make money off of incarceration, ensure that they continue to have a full, their coffers filled, it would only require overturning Roe v. Wade and permitting the prosecution of pregnant women. 6 million women get pregnant every year in the United States. Approximately 1 million of those have abortions, and another 1 million of them, approximately, have stillbirths, miscarriages, or give birth to a baby who dies very young. which is to say miscarriage, stillbirth, and pregnancy losses are a common, not unexpected part of pregnancy. It's estimated that by the age of 45, 1/3 of all women in the United States, or approximately 1/3 of all women in the United States, will have had an abortion. And again, the people who have abortions aren't different from the people who don't. 61% of women who have abortions, when they're in their 30s, 61% of them are already mothers. So there isn't one kind of women who has abortions and another kind who has babies. They're all the same women, just at different moments in their lives. And 84% of all women, by the time they're in their 40s, have gotten pregnant and given birth. And many of them increasingly face state interventions and punishment that are inappropriate. We wanted to look specifically, as we saw this growing rate of incarceration of women, incarceration of mothers, what we could find out and document about the incarceration of women when pregnancy was a necessary element of the crime, or in most cases a but-for element. In other words, if she hadn't been pregnant, whatever it was they were saying she did would not have been a basis for an arrest or prosecution. We did a peer-reviewed study and found that between 1973 and 2005, we were able to hard document 413 arrests. It looks like this on a map. I would say that now arrests have happened in every state. And if I can go back, yeah. If you'll notice, the peak of arrests occurs in the late 80s, early 90s, when there was the incredibly oversaturated alarm about so-called crack babies. The crack baby myth was at its height, an excuse to target and punish particularly low-income black women. But when the corrections finally started to happen, and people were saying there's no such thing as crack babies, stop saying this, we still see all these arrests through to 2015. And we wanted to figure out why, and we're going to talk about that. We do know that this number is a gross undercount. It's an undercount because the crimes that women were charged with are not listed as pregnancy specific. They're things like endangerment of a child, delivery of drugs to a minor with the prosecutor claiming the delivery occurred through the umbilical cord. So there's no criminal database that you can go to and look up and say which are the cases involving pregnancy as a necessary element. We also had numerous statements by prosecutors, newspaper articles, which indicated that in particular states there might have been 5 or 10 more arrests than we were able to hard document, or as many as 100. We found that 72% of the women, not surprisingly, subjected to these arrests and detentions were low income. 59% were women of color, and 52%, a grossly disproportionate to their population number of women, were black. 84% of the cases that we were able to identify did involve an allegation of both the fact that the woman was pregnant and had used a criminalized drug. It's not just punishment for using drugs while pregnant, it's pregnancy and drug use. Both pieces have to be there. And what's interesting about these cases, if I may for a minute, is how clear it is that the pregnancy itself and giving birth, things that only people identified as women do, or mostly identified as women do, is how clear they make that this is about pregnancy. So we've got 3 arrest warrants, affidavits in support of arrest, in 3 different states. And the crimes in these states, this was criminal neglect of a woman accused of being pregnant, becoming pregnant using a drug, and part of the charge says in it, her crime was willfully and unlawfully giving birth to a male infant. It actually articulates the giving birth as an element of the crime. And that was South Carolina. It was true in Ohio, again, to which she gave birth to an infant child. So being pregnant and giving birth becomes an element of the crime. And that should give you a hint that there are constitutional challenges to these kinds of cases. And in Nevada as well, you have a charge of willfully endangering a child. It's a drug use and pregnancy case, and you have in that said defendant gave birth. So they're kind of disguised. You might think it's just a run-of-the-mill drug case or something like that, but in fact, absolutely essential to these cases is birth and pregnancy. So while most of the cases that we documented at that point had an allegation of drug use, 16% did not have any allegation of use of any criminalized drug. So what were women being arrested for? Well, many of the cases of this 16% were women who were actually arrested for having what was called an illegal abortion. The allegation was she intentionally sought or did terminate a pregnancy or took some act that terminated a pregnancy, and that made it a crime. What I'm proud to let you know is that when we've had the privilege of becoming involved in a case, we have overwhelmingly succeed. We typically succeed in getting charges dropped or dismissed altogether. In some cases, it's resulted in a negotiated plea to a lesser charge or a significantly lower sentence, except in the states of South Carolina and Alabama, where we continue to develop new efforts to create legal and political challenges to the judicially created arrests there. But in spite of all these arrests, in literally dozens of states, we unfortunately continue to see more and more what appear to be a growing rate of targeting women in relationship to their pregnancies for arrests. And these are just two graphs based on our research and investigative reporting by Nina Martin, showing the difference between the almost 40 years or 35 years from 73 to 2005 and the much shorter period from 2005 to now, where we see and are able to document many more arrests. Why is this happening? Why do we think you're likely to see one of these cases, if not very soon, if not now, very soon? Part of it is that we exist at a time where the rhetoric around abortion is so harsh. So it's just wrong or it's immoral. You've got protesters and laws that describe abortion as killing, as murder. And while those who support anti-abortion laws say, oh, this is just directed at the doctors, we, as human beings, all know that the people who have abortions are women, and most of whom are already mothers. And it is a kind of public defamation of and characterization of America's mothers as murderers, as people who are committing murder, who are getting away with murder, and may not yet have laws that permit punishment. Another thing that has changed is that the anti-abortion movement looked closely at Roe v. Wade and said, how can we get it overturned? One of the things Roe v. Wade said is that in this country, fetuses are not recognized as persons in the whole sense. And so they've had a very long-term strategy of trying to get as many laws passed as they can that describe or define fetuses as separate persons. And the most recent laws like these have really said from the moment of fertilization, not just viable fetuses, but from the moment of fertilization, it should be treated, the fertilized egg, embryo, or fetus should be treated as a separate legal person. And one kind of law like this, most common, are feticide laws. 38 states now have these laws. 23 of them define the protection of the so-called unborn life from the moment of pregnancy, which means from the moment a woman becomes pregnant, she may not even know she's pregnant. These states are viewing her as carrying a separate life. And many times people talk about these cases as if they're maternal-fetal conflicts, a conflict between the mother and the fetus, but really they're a conflict between the pregnant woman on her behalf and behalf of her pregnancy and state authorities to surveil, control, and punish her. Most of these laws were passed in the wake of extreme violence by a third party against a pregnant woman. Most of them specifically say it does not outlaw abortion or apply to the woman herself, although some are just silent on that. But all of them were passed, at least in part, with the claimed intent of protecting pregnant women from violence. The other thing that's changed is just more and more and more laws seeking to restrict abortion. And create challenges of the right to choose abortion in the Supreme Court. Those laws have been so effective that we now live in a country where 87% of all U.S. counties have no abortion provider. and that is true of 97% of the non-metropolitan counties. So you not only have a culture that's saying it's okay to look at pregnant women as criminals, a series of statutes that are cited as justification for interpreting the word child to include the unborn. You also have less and less access to safe abortion services in medical settings. And here's a graph from the Alan Guttmacher Institute that shows you how many different kinds of laws. So it's not just laws that necessarily shut down clinics. I think in Mississippi and Alabama there's only one clinic for the entire state. But laws that then, if you can get there, if there is one in your county or within driving distance, there are regulations about how you might have to wait 24 hours and make 2 trips or make 3 trips because you have to have a sonogram, an intravaginal sonogram at a certain time before the abortion, just making it impossible. And so it shouldn't be surprising that in the states, that's a top map, in the state, the top map is states, and the yellow are states with laws that are very, very hostile to the right to access and choose to have an abortion. And the map beneath it shows you research done on where are women investigating how to get an abortion safely outside of a medical setting and without having to be in contact with a doctor necessarily. And there's a pretty good overlap between the searching online for information about safe abortion pills and other methods with those states that are most hostile to women having access to abortions at clinics under the supervision of physicians. And fortunately, there are now, abortion is, well, let me just go ahead. We now see a lot of newspaper articles about this thing that in some places are called the rise of the do-it-yourself abortion, DIY abortion, using that term, the dawn of post-clinic abortion, the rise. So this is popular media is carrying stories like this a lot. The good news is, as Justice Ginsburg noted in the most recent U.S. Supreme Court decision on abortion in 2016, Whole Women's Health, that abortion is safe. And it has been safe for a very long time, whether it's performed with instruments or whether it is performed simply with medication or medicinal abortions. Justice Ginsburg in Whole Women's Health noted that many medical procedures, including childbirth, are far more dangerous than abortion to patients, that complications from an abortion, or any kind of abortion, are both rare and rarely dangerous, and that abortion is one of the safest medical procedures performed in the United States today. What's been interesting, lessons learned from around the world and understood by increasing numbers of women in the United States, there are now medications, 2 pills, that are very successful in ending a pregnancy. These pills, and there's a little video in the material, if you've gotten the material beforehand, there's a video resource that explains it. Here are 2 websites, 2 different websites, that explain how to use these medications safely and effectively. Abortion with pills now account for close to half of all abortions in the United States under the supervision of a doctor. It's increasingly recognized that abortion with pills can be carried out safely in or outside of an abortion clinic with or without supervision of a doctor. The 2 medications used for this are mifepristone, a medication that works by blocking the effects of the hormone progesterone. Without this hormone, the lining of the uterus begins to break down, and followed by another medication that hopefully will be taken 24 to 48 hours after, a medication called misoprostol that induces contractions of the uterus to expel its contents. And so you have these websites that tell you how to use them safely, when to use them. Neither of them, nor any of the others, will tell you how to obtain the medication or how to obtain the medication, nor will they send it to you for fear of some kind of legal action for making it possible. That does not mean women can't get the medications, and clearly, as the cases we'll be discussing show, we finally have this more headlines that really look at reminding people, and unfortunately this was a little East Coast biased in the newspapers. We know that these stories are appearing in all kinds of journals, online sources, and throughout the country, providing this information. One of the things about these medications is that it's recommended that they're used in the first 10 weeks of pregnancy. The fact is that they are often used much later than that, and both the experience of women actually using them all over the world and research is that they are effective and safe even when used much later in pregnancy. Sometimes women are using them much later in pregnancy because they don't realize how far along they are in their pregnancy. The assumption that women instantly know they're pregnant or how far along they are in their pregnancies or even that they really, really are pregnant, since some women are told they can never get pregnant and turn out that they do, is a mistake. So if a woman does take the medication and it works, as it is likely to work, she is going to find that she has to deal with fetal remains and does not know what to do with them. And that's how some of these cases come to public attention, to police attention, and you will now be hearing about some of those cases.
Before we move on, we have had a question come in. Isn't it illegal in the United States to order medications online without a prescription?
Well, that's a great question, and it points up the part of the importance of this webinar is informational for you as practitioners. I suspect as well there's plenty of women watching, and probably some men as well, who are getting this information and wondering in their own lives and in the lives of the people that they interact with what the truth is about these sorts of issues in relevance to their own lives. And so the question of is it a violation of law to order these sorts of medications online and buy them without a prescription is a legitimate one, and it's one that's asked frequently. The answer to it is that the answer lies in the FDA's regulations, and the FDA explains that it is illegal to import controlled drugs into the United States. However, the FDA also provides guidance to us in the United States and explains that it typically does not object to personal imports of drugs that the FDA has not approved under certain circumstances, including the following situations. If the drug is for use for a serious condition for which effective treatment is not available in the United States, remember, 87% of counties don't have abortion services. There's no commercialization or promotion of the drug to U.S. residents. The drug is considered not to represent an unreasonable risk. The individual importing the drug verifies in writing, though it's not clear to whom or when or how, that it is for his or her own use, and provides contact information, though it's not clear to whom or how or when, for the doctor providing treatment, or shows the product is for the continuation of treatment begun in a foreign country. And generally, and this is sort of the key, generally not more than a 3-month supply of the drug is imported. So typically, the women whose cases involve the mail order of misoprostol and mifepristone are exposed to potential federal prosecution, but it doesn't happen, and we're unaware of it happening. It would be wrong, however, for us to inform any client that it couldn't happen. It's just that it doesn't happen.
And I would just suggest, to get a sort of feel for what this means, is if you haven't seen the movie The Dallas Buyers Club, you might want to, because we know that during the AIDS epidemic and HIV that people were finding a way to get the medication they needed to survive. And while there were some cases, by and large, the importation for individual use was not prosecuted.
The FDA cares about, and this was part of the Dallas Buyers Club story, the FDA cares about people who profiteer on importing drugs that are otherwise controlled. And certainly an individual woman ordering one of these drugs for themselves is not profiteering by it. Yep.
So where we are is a new reality. Women are being charged for murder and other homicide crimes after self-inducing abortions, having abortions outside of a medical setting. I'm going to talk for a little while about some of NAPW's cases, the cases we've been involved in. because, and if you're thinking about the fact pattern for this training, which we'll go over later, you'll see that these cases have elements that fit into that fact pattern. And few of the cases so far have been directly for abortion, explicitly about you had an abortion, you are a murderer. But there are some, and certainly more cases will be coming, despite the claims by anti-choice groups that women are not and should not be punished for having abortions. We see more cases involving drugs and pregnancy. But many of the same theories that we will describe with regard to the abortion cases, the prosecutions, also apply to the drug cases. So I don't know if you can see the slide. We squished together three things there, but this slide is really meant to illustrate that we're in an era which people know of declining access to health insurance coverage. We have states opting out of the ability to expand Medicaid in their states. We have a severe threat to the Affordable Care Act going on right now. And at the same time, we have these increasing efforts to prosecute and punish women who are unable to get health care in a traditional setting. So we see cases like this, and I'm just going to briefly talk about some of the types of cases we see, not with regard to abortion, but with regard to drugs. This slide depicts two women from Wisconsin, Alicia Beltran and Tammy Lecher, who both were the victims of what felt to them like a criminal prosecution, although it was civil. Wisconsin has a law currently that we're challenging in federal litigation, which allows for the detention for forced treatment of pregnant women who are alleged to be using alcohol or drugs, such that a social services official of some kind thinks there will be a substantial risk of harm to the baby. These laws come from the crack baby scare. They come from misinformation, incorrect or junk science about the effects of drugs on pregnant women, and more importantly, the effects of drugs on the developing fetus.
But you forgot that it is currently, the current district court decision. We've had a victory.
We have, I know. I'm a litigator, so we never win till we really win. We did win in the federal district court. Now on appeal in the Seventh Circuit, we currently have an injunction against that law. It was struck down as unconstitutional. But that's not what this training is about.
We got to talk about the victories.
All right, we have to brag occasionally. It's going well, and our client is very pleased but nervous and really, really doesn't want this to happen to anyone else because of what she went through. This slide covers an excellent ProPublica story that was about Alabama, where, as Lynn mentioned earlier, things have gotten pretty out of control in the Department of Prosecuting Women in relationship to their pregnancy. Alabama has a law involving chemical endangerment of a child, a criminal law, which was meant to prevent parents from bringing their children to meth labs and exposing them to dangerous chemicals. But clever prosecutors in the state of Alabama decided to try prosecuting pregnant women who were alleged to use drugs on a theory that the dangerous environment they are bringing their child to, meaning the fetus, is the uterus. And that's the dangerous environment. So there have been hundreds, more than 700 of these cases. They're very hard to count because they happen so quickly and people take pleas so often. That is going on. Unfortunately, the Supreme Court of Alabama says this judicial expansion of this law was okay under certain theories, so these prosecutions continue. There is really a visceral reaction in this country, as many of you already know, to drug use of any kind, and certainly when it involves parents and drug use. Anybody who's done child protective cases understands this too, and certainly when it involved drugs and pregnancy, that is just a terrible combination when it comes to what prosecutors like to try and do things about. So I'm going to turn to selected cases, as I promised earlier, before I started talking about other things, that illustrate the types of criminal statutes that are used and how these prosecutions for pregnancy play out. I'm also going to, with regard to each of these selected cases, talk about some lessons that we've learned from them. And the cases, I'm going to talk about 5 or 6 cases. National Advocates for Pregnant Women has been involved in every one of these, either as counsel on the case or assisting counsel, or as amicus and helping coordinate broader amicus efforts. So the first slide you're seeing is involves the case of Jenny Mccormack. This one is out of Idaho. She was a mother of 2 in Idaho, and she was charged with a crime for self-inducing an abortion with medication she got over the internet. Parenthetically, Ms. McCormack lives in southeast Idaho, where there are no abortion providers in any of the 8 counties, and the closest provider is in Salt Lake City in Utah. The charges against her were dismissed after some public outcry and quick action by her lawyer, but the charges were dismissed without prejudice. And so she sued in federal court about the use of this law against her. So what happened as a result of the federal lawsuit was that the district court entered a permanent injunction, issuing a really important ruling that prosecuting women for terminating their own pregnancies violates their constitutional right to reproductive privacy. In 2013, the Ninth Circuit Court of Appeals upheld that ruling, and it's the first and at the moment the only federal court decision. Lynn said earlier, the U.S. Supreme Court has not ruled on whether women can be prosecuted for having an abortion themselves. This is the first federal circuit court decision saying that's not okay to Idaho. And here you see some slides about the victory in that case. And the Jenny McCormack's case is the one that really is closest to today's fact pattern, which we're going to get to. The lesson that we learned a couple lessons from this horrible experience that Ms. McCormack went through. One is we've got 6 states right now that explicitly have laws on the books, explicitly saying the criminal abortion law cannot be used against the woman herself.
It can be used against.
Can be used, I'm sorry. It's wishful thinking. But the lesson learned from the McCormack case is that even if you are in one of those 6 states, and even if your client has been charged under that statute, which says the abortion law can apply to the woman herself, don't assume the law is valid as a matter of statutory construction and constitutional law. As Ms. McCormack showed, sometimes those laws will get struck down. So, next case I'd like to talk about is a case that was much in the news that you may have heard about as it was going on. It took place in Indiana, where Pervy Patel was accused of very serious crimes. The case was initially framed as a so-called dumpster baby case in the press, in which a woman gave birth to a baby and abandoned it. But as a result of NAPW's work with many other allies, getting the right kind of media attention, getting activists on the ground really involved, the case really became understood as a case about the overreach of the government in seeking to punish pregnant women, and particularly women of color, who seek to terminate a pregnancy. So I'm going to show you a short video clip which describes what happened in this case.
Now.org, The War and Peace Report. I'm Amy Goodman with Nermeen Sheikh.
We turn now to Indiana, which has been in the spotlight this week over its new anti-LGBT so-called religious freedom law. But the historic application of another law in the state has received far less attention. On Monday, Pervy Patel, an Indian-American woman, became the first person in U.S. history sentenced to prison for feticide for ending her own pregnancy. In 2013, Patel arrived at a hospital bleeding. She told doctors she had a miscarriage and disposed of her stillborn fetus in a trash receptacle. Under questioning by police, Patel said she had believed she was about 2 months pregnant. After miscarrying in the bathroom, she said she tried unsuccessfully to resuscitate the fetus, which wasn't moving. She told police, quote, "I assumed because the baby was dead, there was nothing to do." Bleeding, in shock, and not wanting her conservative Hindu parents to find out, she disposed of the fetus and went to the hospital.
Prosecutors would later accuse Patel of taking drugs to try to end her pregnancy based on text messages to a friend where she discussed buying the drugs online. But no evidence of abortion drugs was found in her body. The prosecutors also used a discredited float test to claim Pervy Patel's fetus, which they said was between 25 and 28 weeks, was born alive. So in addition to feticide, Patel was charged and convicted of neglect of a dependent. On Monday, a judge sentenced Pervy Patel to serve 20 years in prison. In total, her sentences actually add up to 41 years, but will be served concurrently with 10 years suspended. The sentencing comes amidst a growing...
So this is a pretty horrific case. And as I said, NAPW was very involved in this case from the beginning, supporting Ms. Patel, and many, many advocates in Indiana and nationally also got involved. There was an appeal filed. Ms. Patel had excellent pro bono offers of help, and her appeal was really wonderfully done, and she won. Ultimately, the appeal was successful. The state determined not to appeal to the highest court in Indiana, and Ms. Patel was freed. Sorry.
Well, I was just going to add that one of the most significant things is this was an attempt by Indiana to use their feticide law, they're one of the 38 states, to punish a woman where the evidence was that she had obtained misoprostol online and used it to terminate a pregnancy. And it's a very important decision since many prosecutors have sought to justify whatever crime they've charged a pregnant woman with based on their state's feticide law. And this is a very clear ruling that says Indiana's feticide law, even though it doesn't explicitly say it doesn't apply to abortion or pregnant women, may not be used to punish a woman in relationship to the outcome of her own pregnancy.
Mm-hmm. Thanks. One of the things that happened in this case, which really is a lesson learned, and it's I know from experience that it's a hard thing for many criminal defense lawyers, public defenders, and others to grasp and to really believe that it works, because I've been there with hundreds and hundreds of cases. We often encourage people to use amicus briefs at the trial level in individual criminal cases. It's really unheard of for a lot of people. I was even surprised when I came to NAPW to find that this was a strategy, and I rolled my eyes a little bit. It really works, and this case, in the right case, obviously. In this case, there were amicus briefs from, public health and human rights and other kinds of groups at the trial level and the appellate level. And this national attention, along with the press and the organizing, brought offers of help to Ms. Patel, including legal help and expert help, and really we feel contributed to her ultimate victory in the case. The other lesson learned from this case, which we've said before today, and we'll say it again, is that the court recognized that a feticide law that did not explicitly exempt pregnant women could not be used to punish pregnant women.
Yeah.
Did you want to add something?
No, we've got it twice.
Okay. So moving on to Georgia. And this is a case in which Lucia Jones, who's pictured here, was arrested in 2015. She was held without bond on a charge of malice murder for allegedly using the drug misoprostol that we talked about before to have an abortion at home outside of a medical setting. She lives in rural Georgia. Malice murder she was charged with, and also possession of a controlled and dangerous drug. And by that drug, the prosecutor meant the abortion medication. So misoprostol is the drug that was alleged to be dangerous, and it's not dangerous. But she was charged in court in Albany, Georgia, And for those of you from New York, it's not Albany, it's Albany when you're in Georgia. The media and activists immediately came to NEPW for comment and analysis. We spoke out against the arrest. Others spoke out against this arrest. There was a real organizing effort on the ground from groups out of Atlanta, several hours away. And the county prosecutor quickly turned around, issued a press release even, saying essentially, oops, sorry, there really is no legal ground in Georgia for charging a pregnant woman with murder for terminating her own pregnancy. But although the murder charge was dropped against Ms. Jones, of course she still faced the drug charge, and she had endured the trauma of an arrest and incarceration for 4 or 5 days, and violation of her rights to medical privacy and personal privacy, and still faced this misdemeanor charge. So one of the things we did, and would be happy to do in a case that you have, is NAPW helped find her a criminal defense lawyer who worked with us. We drafted motions for the lawyer to revise and use, several pretrial motions, motion to dismiss, to suppress evidence. Those motions were filed. The case sat around for a while. Ms. Jones luckily was out by now of jail. And eventually the DA dropped the drug charge as well. After that, because Ms. Jones lives in a small town and this case was in the press, and she, at her request, but she couldn't get a job anymore because of all this hanging over her head, she felt very strongly she wanted to file a damages case. So we also assisted her in finding a lawyer to take on her federal Section 1983 damages case, which was filed a few weeks ago. So one of the lessons from this case, the immediate public outcry by NEPW and our allies led to the homicide charge being dropped. And also the lesson learned is that a general murder statute that does not specify pregnant women is not okay to use to prosecute a pregnant woman for having an abortion. Misoprostol is not a dangerous drug, and the drug charge should not be used as a way to criminalize abortion. Quickly moving to Tennessee for a moment, we also assisted Anna Yaka, a woman in Tennessee who, according to news reports and court documents, attempted to terminate her pregnancy at home with a coat hanger. So she presented at an emergency room and she was admitted to the hospital. Several days later, she gave birth to a premature baby and was indicted on the charge of attempted first-degree murder with a bond set at $200,000. When we learned of the case, NEPW and a network of allies in Tennessee reached out to Ms. Yaka and her lawyer and assisted with those efforts. After the attempted murder charge was eventually dropped, the prosecution just kept coming. They charged her with aggravated assault under a law that Tennessee had in effect for about 2 years, a Fetal Assault Law. And of course that Fetal Assault Law, to just add insult to injury, had been passed to deal with drug abuse. But here it is being used for someone who allegedly tried to give herself an abortion with a coat hanger. So Ms. Yaka's prosecution under that legislation, the Fetal Assault Law, really confirms that laws that seem to be focused on one group of women, drug-using pregnant women in this case, can provide precedent for punishing all pregnant women, including those who are seeking to end pregnancy. So, as I said, we worked closely with her and her lawyer, helped with a motion to dismiss the Fetal Assault Law charge as well. In the face of that very strong motion and lots of support, prosecutors then threw 3 new felonies at Ms. Yaka. One was aggravated assault with a weapon. That was the coat hanger, and the victim was the fetus, or allegedly. And 2 laws from the late 1800s that they dug up. One is attempted criminal abortion, and the other is attempted procurement of a miscarriage. So, having been incarcerated for more than a year, unfortunately, Ms. Yaka determined to plead guilty to attempted procurement of a miscarriage, the lowest crime, still a felony. and was released immediately with time served and no fine and no condition of release. So even though she ended up with a conviction and did spend quite a long time in jail, the lesson from this case can be that fighting this stuff works. Even if it's not the perfect outcome, it's a good outcome. Fighting works. A woman who was incarcerated but fought against this prosecution anyway, and her life circumstances did not make it easy for her to do that, by the way. The result was the prosecution just kept trying to pursue more and more charges, lesser and lesser charges, and eventually settled with a plea.
So before we move on, it's really important in terms of that case, and if any of you Google the Yaka case, you'll see, as Nancy said, that she spent nearly over a year in prison waiting for this case to get resolved with time served. And you're going to hear us talk a little bit later about the importance of, and this is news to any practitioner, the importance of bail and getting pretrial release. This case virtually guaranteed to have a different and better result if that woman had been out of jail during the pendency of the case. And we can never fault a defendant incarcerated for taking a plea and pleading guilty in order to get out of jail. And that was the offer that was made to her. It didn't make sense for her, in her own mind, for her to stay in jail when she had the keys to the door handed to her. But had she been out of jail, an early and aggressive bail application could have resulted in an even better result than what ended up happening for her.
Thanks, Dan. So 2 more cases that really teach us some lessons. Moving on to Arkansas, here's a slide about some of the press around our client, Ann Bynum, who we, NAPW, are currently representing on her criminal appeal. Ms. Bynum lives in Monticello, Arkansas, a small town, and local law enforcement alleged that she took pills, after which her pregnancy ended with delivery of a stillborn baby while she was alone. The investigators said that several hours after that happened, she went to the hospital, bringing the fetal remains with her. She was arrested 5 days later on charges of concealing a birth and abuse of a corpse. Anybody ever heard of those? Those are both felonies in Arkansas.
But tell them what the concealment was.
So the concealment of birth alleged here, she's an adult woman, she has a young son, and she was living at home with her mother, and she didn't want her mother to know she was pregnant. So she was charged with concealing a birth essentially from her mother, because Arkansas, she's a grown-up, she's in her 30s. Because Arkansas doesn't have a reporting requirement that if you have a stillbirth at home, you have to report it to anybody. The faces in the room are looking really horrified. I want to tell the people watching at home. It was horrifying. And abuse of a corpse for having a stillbirth and waiting a few hours before she carefully and tenderly brought the fetal remains with her to the hospital. So these are the charges, and we're going to see in a minute that this case really wasn't about that. It was really about abortion. It was an anti-abortion case. So we connected with Ms. Bynum and her counsel. We drafted a motion to dismiss the charges, making sure all those constitutional arguments were raised below, which turned out to be very important because now we can raise them on the appeal. And if we had not preserved those issues through her trial lawyer, they wouldn't have been able to be raised. What happened at this case, which went to trial because there were no offers being made, at the close of evidence, Ms. Bynum's lawyer succeeded in persuading the judge to issue a directed verdict on the abuse of a corpse charge, but the judge let the jury consider the charge of concealing a birth. The entire trial was about abortion, was about that she had had previous abortions, was about that she was a loose woman. I mean, really, the transcript is pretty shocking here. The jury deliberated on this charge of concealing a birth for 4 minutes and returned a guilty verdict and sentenced her to 6 years, of which she will have to serve 1 year if the conviction is upheld.
Right. The jury deliberated for 4 minutes, and then in Arkansas, the jury sentences as well. They heard the sentencing argument, and they deliberated for 14 minutes before returning the harshest sentence possible of 6 years.
Yeah.
Happily, she got a stay on executing the sentence pending the appeal, and
Right, so she's currently out, although she is restricted to living at home with her mother, along with her young son. And we are representing her, this group, plus some other folks, on her appeal, which is currently being briefed. So what's the lesson from this case? One lesson is that this is the optimistic way to look at it, because we hope we win on appeal, and we have a very strong case. One lesson is that facts matter. The facts of the case really do matter, and the facts did not fit the law here. We believe that's why the directed verdict was issued, and we hope the conviction will be reversed on appeal. This was treated as an abortion case. The prosecution repeatedly appealed to the jury's anti-abortion sentiments in this rural county in Arkansas, although abortion was not and could not be charged. Clearly, the prosecution was to punish Ms. Bynum for pregnancy and what appeared to be an abortion attempt, but they couldn't charge her with that crime specifically. Given the facts of the case, the prosecution came up with concealing birth and abuse of a corpse as a surrogate, really, for an effort to penalize abortion. I'll let you sit with that one for a second while we go to Virginia. This is a currently pending case. This is Michelle Roberts. She was indicted a couple of months ago in March of this year for the felony charge of producing an abortion or miscarriage. She was pregnant and gave birth to a stillborn baby. She and her adult daughter buried the baby in the backyard. She was not happy to have the stillbirth. She was sad. She gave the baby a burial. According to various news sources, somebody told somebody in law enforcement about the case, and the local police department got a search warrant, found the fetal remains buried in her backyard, and also somebody told the press that Ms. Roberts had been participating in a methadone maintenance program for several years. How that is related to these charges doesn't seem apparent, but we know why. So right now, NAPW is working along with a couple other organizations to support Ms. Roberts and her defense attorney. We've drafted a motion to dismiss for his modification and use, arguing that this Virginia statute cannot be used to prosecute a woman in relation to her own pregnancy, and that if such an application of the law were permitted, it would violate the United States and Virginia constitutions. So right now, Ms. Roberts has been released on bond, and she's awaiting trial. The motion to dismiss will be filed shortly. One question that comes up around a case like this and around cases that we've been talking about that I'm not even calling on Diane to read to us because it just comes up so frequently, we're just going to ask it, is sort of a confusion. What is the difference between miscarriage and stillbirth and neonatal death and abortion? How is that difference meaningful in cases like this?
It may be very meaningful to the person experiencing these things, but the bottom line is that pregnancy is a possibility, not a promise. That OBGYNs typically neglect to tell women, especially those who are happy about being pregnant, congratulations, but you should know that 15 to 25% of pregnancies end in miscarriages or stillbirths. Here's what you do if these things happen, because women don't know what to do. So it's a common part of pregnancy. We know from countries around the world where abortion is criminalized and women are punished that very often a woman who has not taken any steps to end her pregnancy, who had no intention of ending her pregnancy, but experienced a pregnancy loss through miscarriage, stillbirth, or giving birth to a baby who doesn't survive, have been charged with criminal abortion and or murder. And it's important both because if we believe that crimes can only be charged if there's a certain intent, very often once you're in a courtroom, it doesn't matter what your real intention was. The judge or the jury will decide that for you. And so one of the many reasons why no law should ever be passed or enforced or upheld that criminalizes abortion is because there's really no way in many instances to tell the difference between a pregnancy that ended as a result of an abortion, an intentional act to terminate, and just a pregnancy loss. Pregnancy is a health condition. The species will not survive if women don't get pregnant. Some of those pregnancies will be lost, both in many different ways, but none of those pregnancies should be addressed through the criminal justice system.
All right. So we've taken a lot of our time to talk to you about the sorts of cases that NAPW has handled. The vast majority of them handled quite successfully. There's really something to know about handling these kinds of cases. And the work that goes into these is particular to exactly these kinds of cases. So, we've all participated in continuing legal education and advocacy training, and frequently we leave those trainings with the feeling that while the ideas are great and the strategies are stimulating, it would never work back home in our local courts. We couldn't try that there. We hear that all the time at the best trainings. So the truth is that the strategies that we're talking about, that we're speaking about today, have worked. And they have worked in South Carolina, in Indiana, in rural Tennessee, in rural Arkansas, in Idaho, in Oregon, and Georgia, and Virginia, and many other states. They will work. You move outside of your comfort zone, and you try something that you haven't tried before, and that's what we're here to help you do. So when the opportunity arises, put out a call, and we'll be there to help you through it. We've done it before, and we'll do it again. So we'll discuss the law and strategies for these cases, and when the time comes, as I said, just pick up the phone and we'll provide you with all the support you need, from brief writing to hiring experts, to investigations, to trial prep work, to appellate work, or even co-counsel if you want it. The strategies are novel, but they nonetheless can be winning arguments wherever you are. So you see on the screen in front of you the fact pattern that we're using for the last portion of this training. It's available to you as well in your downloadable materials. If you've downloaded it, you can take a look at it. I'm going to review it briefly, and then we're going to apply some of the facts of this hybrid case to the sort of analysis that we would use, and we hope that you'll use in looking at one of these cases should they come your way. So we've identified Samantha Green, who lives in state X, your state. She discovers she's pregnant. She's already the mother of two, and she does not want to bring this pregnancy to term. Part of her reason for wanting to terminate the pregnancy is that she's worried about her own drug use. Has marijuana on the weekends, methamphetamine on occasion, and before she knew she was pregnant, she was concerned. She took those drugs, and now is concerned that she may have harmed the fetus. Living in a rural area with no abortion providers, as you heard, in 87% of the counties in the United States, and no money to get to or have a clinic-based abortion, she orders misoprostol online from Canada and uses it successfully to end her pregnancy. As we told you, misoprostol is a safe medication and effective in ending a pregnancy when used properly. And as it turns out, she was already in her second trimester at approximately 24 weeks, which in many states is defined as the beginning of viability. She didn't know what to do after she did miscarry. She didn't know what to do with the fetal remains, and so she thought that she should just bury them, which is what people do with things that die. And Ms. Green told her sister about the abortion. Her sister then told a friend, and some friend informs the police. The police responded by going to Ms. Green's home, arriving just as she finished cleaning the house and putting her youngest child to bed. And once at her home, the police start questioning her. Your defense attorney antenna should be quivering at this point, questioning her in her own home. Could she leave at that moment? Did she believe that she was in custody? These are the issues that you ask yourself in any case where there's any police involvement. And in the course of questioning, Ms. Green leads them. How does she lead them? Why does she lead them? To the place where the fetal remains were buried, and then goes to the police station. Goes willingly, is escorted. How does she get to the police station? What are the conditions of her confinement on the way to the police station? Where she's questioned further, is she Mirandized? And then at the end of that questioning, she's released pending further investigation. The further investigation results in a variety of charges being brought against her. The number of charges which are being brought against Ms. Green in our hypothetical are extensive and would require a really gung-ho prosecutor, but they're important to show to you as the kinds of charges based on these fairly innocuous facts that a woman could be facing. So she's charged with, because she lives in one of the 6 states that has laws specifically saying that a woman may be punished for attempting or actually to carrying out an abortion on herself, she's charged with criminal self-abortion. She's charged with feticide for causing the death of her fetus. 38 states have those laws. She's charged with practicing medicine without a license. She's charged with concealing a birth. She buried the remains. She's charged with improper disposal of human remains, and we'll get back to that in a moment. She's charged with abuse of a corpse. She's charged with criminal child endangerment, with possession of dangerous drugs, and with delivery of a controlled substance to another. You know, the notion of improper disposal of human remains is a kind of charge that's brought up frequently, and it's brought up in our state as well, in New York State, when someone gets rid of the remains after a miscarriage. But that's not the only time that remains are disposed of in fairly innocuous ways. It's happened before.
Yeah, I was telling Dan earlier about a story that some of you might have seen in the news about a man whose friend, a fellow Mets fan, baseball fan, had died. And the friend is on a mission to scatter some of his friend's ashes in baseball parks around the country. Amusing human interest story, right? So this guy goes around scattering some of his friend's ashes by flushing them in a toilet in a baseball stadium all around, because he thought his friend would think that was hilarious. So that's a fun story, but somebody burying in the backyard the baby they wanted but who was stillborn is a crime.
So the same behavior, the same human remains, but you're a pregnant woman or a formerly pregnant woman doing this, you get charged with a crime. You're a guy at a baseball stadium, you get a beer bought for you. So what do you do when you get a case like this? You do pretty much the same things that you do in any case. You look at the statute. How does the statute define the behavior, the crime? You review the elements of each of the charged offenses. If you're clever, you look at the jury instructions, the jury instructions that already exist for these precise offenses, and you see what elements need to be satisfied in order for the charge to go to a jury. These are unusual cases, and the police and the prosecutors will will not be accustomed to parsing the evidence to establish each of the various elements, so you get a foot up if you know all of the elements at the beginning of the case. Some of the statutes require that there be a fetus born alive, and there's a particular issue as to that.
Okay.
Yeah.
Well, two things. One is, most importantly, even if the baby is born alive and dies, sometimes that's confusing because it seems like, well, we're not dealing with fetuses, we're not dealing with pregnancy. But if the alleged actions that make it a crime occurred only during pregnancy, if the woman didn't do anything following the birth, or as in some of these cases, they undergo cesarean surgery at the risk to their own life to give birth to a baby that doesn't survive, these are still cases that in which pregnancy is the necessary element, that they should still be challenged. We're just getting to a motion to dismiss. In these cases, it's very important to realize that whatever the language is, there's probably a way to challenge it. I checked the date. I think we still live in a country where there's separation of powers. Typically, the state and the federal constitution, there's separation of powers. Judges are not allowed to create new law. Usually the state constitution says that. It might be a statement at the beginning of your state's criminal code that it's the legislature, not the courts, that create crimes. I think South Carolina is the only exception to that. And generally states have the rule that any ambiguity in a law should be resolved in favor of the defendant. And that's true in all criminal cases. When a prosecutor takes a statute like criminal child endangerment, because the woman got misoprostol, or delivery of a controlled substance to a minor, or dangerous possession of a dangerous drug, the argument being through the umbilical cord, there are many plain language challenges to that statute. The word child doesn't include fetus. The statute doesn't mention pregnant women. And we know that in criminal cases there has to be clear notice. So when we have been able to help in many cases where we bring a challenge that starts with plain language, if the statute is ambiguous, then you get to look at legislative intent. In the Anna Yoka case, the legislation was really ambiguous. It was kind of, they were trying to sneak in penalties for any action a pregnant woman took, any action that was any illegal action or omission. And arguably, that could apply to using a coat hanger, I suppose, during pregnancy. But since it was ambiguous, it was the rules of statutory interpretation say you can look at legislative intent, and the absolute, unquestionable, only intent that was articulated by the legislature and the governor when he signed that law was to address, quote-unquote, illegal narcotic use by pregnant women, a woman. So that it was a very powerful argument that the law could not be used to charge women in other contexts. We go through the statutes all the way. We find ways of whether the language isn't plain, if it's ambiguous, it's inconsistent with legislative intent, or would lead to absurd results. Very importantly, if the judge, you can say, Judge, you don't need to reach any constitutional issues. The plain language clearly does not apply to the context of pregnancy, to the facts of this case, to pregnant women in general. But if the prosecutor persuades you to judicially expand the law, or if you genuinely believe the law may be used, authorizes punishment of pregnant women, then it becomes an unconstitutional law on numerous grounds. And it's vital that you at least preserve all of those constitutional grounds, including due process notice. The judge's interpretation is a new interpretation of the law, is the equivalent of an ex post facto law. These laws become vague. If child endangerment, becoming pregnant is child endangerment, given the statistics on pregnancy loss. The right to privacy in reproduction, the right to privacy of medical information, the right to be free from unreasonable searches and seizures, when hospitals collect evidence from women knowing that they're going to turn it over to the police, a variety of equal protection arguments, and freedom from cruel and unusual punishment. Even when statutes do specifically mention unborn children, and even as the Jenny Mccormack case, even when they specifically talk about the pregnant woman or self-induction, there are still challenges that are likely to succeed, particularly with support from not only NAPW, but a range of organizations with expertise.
So we're running a little short on time. We only have about another 7 or 8 minutes, to go, and our hope had been to go through the life of the case through the fact pattern, but there are some issues that I think it's really important for you to be aware of. We touched on it earlier in talking about Ms. Yaka's case. Get these clients out of jail. These cases take a long time to litigate, and your opportunity to get the best result is extraordinarily limited with your client in jail. So you know how to do a bail application. You make your bail application. They have a right to bail. If the judge doesn't grant it, take him up on appeal and fight to get your client out of jail pending the resolution of this case. Express during your bail application that there are significant constitutional issues here, that there's going to be a real challenge to the vitality of the statute under which the client is charged, and get your client out of jail. I'm going to move forward since we are short of time.
I'm going to interject here for a
go ahead.
second while Dan's getting ready to move forward.
Yep.
One thing that criminal defense lawyers don't often do is get medical records for their own clients. This can be really important in cases like these. You might be accustomed to getting medical records of complainants or other witnesses, but oftentimes medical records can show things will be valuable to you, your own client's records. For example, that there was medical malpractice that caused something to happen to her pregnancy rather than something the woman is alleged to have done herself. Get those records, get a release, make sure it's compliant with HIPAA, and take a look at her records.
Excellent. So one of the essential elements that you'll use in these cases, at least from a very early moment, is an expert to provide information about the mechanism of how the woman allegedly violated the law, and the opportunities to use experts when appropriate is huge.
One thing, we talked about experts before and how we can help you get them. I know you're thinking we don't have money to hire all those experts. NEPW has been really successful in arranging for free, pro bono, expert help. So the types of experts who might be needed in cases like this: neonatologist, forensic pathologist, maternal fetal medicine specialist, OBGYN, a former medical examiner to challenge your medical examiner in your case. We really often can get you people to do an affidavit or even to testify. So really, please call us.
You heard earlier that often the government uses quote expert testimony to try to prove their case, and you need to look on that really very carefully. You should be aware of something called the National Academy of Sciences 2009 report on forensic evidence labs and testing that said, and I'm going to just do a very short quote, they found that substantive information and testimony based on faulty forensic science analyses may have contributed to wrongful convictions of innocent people. This fact has demonstrated the potential danger of giving undue weight to evidence and testimony derived from imperfect testing and analysis. Moreover, imprecise or exaggerated expert testimony has sometimes contributed to the admission of erroneous and misleading evidence. We've seen that in our cases, haven't we? No. I think we should spend a little bit of time, and I'm moving away from the fact pattern, on the importance of using the media in these cases. Typically, defense attorneys shy away from using the media at all. The default defender position of no press is just not true in these cases. If you do nothing, nothing will happen. So at the bottom, we're educators. There's been and continues to be a national discussion about the issues these cases raise. The fact that your prosecutor, judge, or community may not have been part of the discussion doesn't diminish the need to educate all of the stakeholders on the law, the history of these cases, the motivation behind bringing the cases, and the moral justification for permitting women to make central decisions about their bodies and their pregnancies. So get over your aversion to using the press. It's important for your clients.
These are just some slides about all the amicus briefs that we have helped people get about organizing and activists getting involved. Two quick things. You may not do interlocutory appeals very often. Every state varies as to whether you can do it. Do it if you can, if there's an adverse ruling, because the most important thing in these cases is to get them dismissed before trial. If you end up going to trial, there are some special considerations you want to think about, such as, is it a judge trial or a jury trial? Depends on your judge, depends on your community and your jury, and you want to think about your tactics accordingly.
Look, remember that your judges are typically elected. They're going to have to protect themselves politically. We want as much error possible in these cases, and there's always more opportunity for error with a jury trial than with a judge trial.
Right. Preserve your issues for appeal.
Preserve. Do you want to close up?
Sure. And keeping in mind that both prosecutors and judges are often elected is one of the reasons why we have found media and activism so helpful in getting to the point where people are dropping, dismissing charges, or ruling for the client as possible. But we always do this in consultation with local organizations and with the appointed or retained counsel. Very important that we try to keep cases from getting to trial, because the human mind is very simplistic. If a baby comes out and there's something wrong, it must be the woman's fault. Very hard for people to look before about what happened to her, what's happening around her. And the critical thing, too, is that, as Dan said, these are winnable cases. Victories in these cases not only protect the client you're representing, but have a great impact on women in America today. And so we want to be sure to be helping you respectfully and forcefully, so that we ensure that nobody, because of pregnancy or their capacity for pregnancy, loses their statutory, constitutional, or human rights. Thank you very much.
Thank you.
One question that we got was regarding amicus support. One of you mentioned having using amicus curiae briefs at the trial level. Our questioner asks, what is the logistics of doing that? Does that person need to file a motion to intervene? Do you attach it as an exhibit, or both, depending on the circumstances? Do you know anything about the logistics of that generally?
That's a good question. Since there typically aren't any rules in state court, in the trial level court, for doing it, we sort of use as a guide what's required in the appellate court and what retained counsel suggest. I don't think it's not intervening. It's not asking to be a party in the case. It's simply providing the court with expertise that might be valuable. And do you want the logistics of it? I just do want to say that, again, a judge is going to be afraid that if they don't rule against your client, they're going to look like they don't care about babies. And the beauty of these amicus briefs is that they are from public health organizations, sometimes advocacy organizations, but explaining that, in fact, keeping the criminal law out of the context of pregnancy protects maternal, fetal, and child health. And it takes the pressure off the judge to feel like there's only one way that he or she can rule.
Yeah, and very quickly on logistics, usually in most states it's a motion to participate as amicus, and the proposed amicus brief is attached. That's the same process that's used in appellate courts. We have sample motions if people want them. We can help you do the research on your individual state and give you logistical support around that as well.
And remember, when that motion to intervene, or motion to file an amicus is filed with the brief attached to it, that becomes a public document. We're educators. It's out there. It gets picked up by the press. And so even if you don't think your court is going to permit it, Do it. It gets out there. Your jurors will see that. It's important to do.
One additional question. We do have a large contingent of folks from Alabama participating
Excellent.
today.
Great.
And we've gotten one question. Being in Etowah County, Alabama, and seeing these charges against pregnant women on almost a weekly basis, what are the unique challenges you see in Alabama in defending these cases?
I'll just start by saying we have had 2 significant losses in the state Supreme Court. It's quite discouraging. And in fact, the court interpreted the chemical endangerment law to apply to the context of pregnancy really as a mechanism for writing concurring opinions explaining why Roe v. Wade should be overturned. These are very interconnected. What I can say is there are constitutional challenges that can still be brought that the court has not ruled on. They've only ruled on due process, one aspect of due process. So if there is a client who is willing to challenge those, it would be really worthwhile to challenge on those claims and then have an opportunity to get into federal court.
Also, Alabama friends, we're developing, along with some of your colleagues, one of whom is from Etowah County, model motion to dismiss these cases, which is pretty detailed and full of Alabama and federal law. So we're planning to be down in Alabama in the coming year, giving some trainings, and we hope to see you all there.
Well, and I would just add that there is a Supreme Court decision, Ferguson v. City of Charleston, and one of the issues is in Alabama, when hospital employees collect information knowing that they have to and will turn it over to the police, there may be a very strong Fourth Amendment challenge that not only is useful for suppression, but could result in personal liability for having violated the woman's Fourth Amendment right.
And when Lynn says Supreme Court, she means the U.S. Supreme Court. That was a case out of South Carolina, so it does apply in Alabama and everywhere else.
So far.
So they tell us.
All right, that'll do us.
That's great.
Thank you.
Well, thank you, everybody.